Okay, I want to talk to you about some proposals that are being considered by the government at the moment. My name is Martin Bear, and I've represented victims of injury and disease for about 28 years. You know, in 28 years I've never actually met anybody who didn't want to turn the clock back more than they wanted to spend time with a lawyer or a judge. Never met anybody who wanted to be injured. So the process is one in which you've got an involuntary participant. You've got somebody who didn't want to be there in the first place, and who was only there because of what somebody else did or didn't do. And what the court is going to be deciding, if that person can get his case or her case to court, what the court's going to be deciding is the actions or the roles of others, and whether they are legally liable to compensate that person for the losses they've suffered. There is no lottery win. You will be compensated, if you win, for exactly what you've lost, and not a penny more. And you know, if you ask people how much the court should award for injuries, people always guess roughly double what the court's actually going to award. So you're not talking about big money. You get some big money awards in the headlines, and the press, they like that. But they are almost always for constant care. Somebody's paying money out, day in, day out, for the things that they need to pay other people for, that they can no longer do themselves. And if you're going to pay a nurse 20 grand a year for 20 years, how much money do you need to pay that person? And that's just to do the things that you used to do yourself. There's no lottery win in any such award. So there you have, on the one hand, you've got this person who didn't want to be there in the first place. And on the other, you've got an insurance company. And the insurance company is in it for profit. The reason why the insurance company is in it is because it took a premium from the person who the court may have decided was to blame for what's happened. The insurance company rated that risk, and they set a level of premium in return for which they would take that risk. They've got very experienced risk management departments. They know what to look for. They know how to advise the people they insure in terms of safe working practices. They don't do it as often as they should, and they don't set premiums perhaps in the way that they should, but nevertheless they've got all of that expertise, and in return for the premium paid by that business or by that motorist, they take the risk. They want that risk. They have a captive market. It is compulsory for you to insure your car or your motorcycle. It is compulsory for an employer to insure against its own responsibility to its employees. You can't not insure, you have to have it. So then you've got a situation where insurers are competing for market share, in pursuit of profit, not in pursuit of any larger or more humane goal, just for cash for the shareholders. So there's the balance set out. If there was a balance, it's an imbalance. There's the involuntary participant who is without legal advice on the one hand, and there is the multinational, multi-billion-pound insurance company on the other, with a team of lawyers always at its disposal. And whatever the government does in relation to the proposals, don't think for a second that the insurance company's lawyers or the insurance company's abilities to spend to support its legal position will ever be affected. It won't. They are never without their own team of lawyers. Instead, what is proposed is that because it is said that the legal costs involved in pursuing an injury or a disease case are too high, and by too high that means too high for the insurance industry, not too high for you or too high for me or too high, I would say, for a civilized society, just too high for the insurance industry. Because of that, it is being said that what you may spend in supporting your case will be controlled. And if it's not, if you exceed that budget, if you like, then you're paying the difference. Or to put it another way, the bigger picture is this. The proposals would leave 39% of involuntary injured victims worse off. I can't think of any other field of human endeavour in which you would deliberately design a system which you know gives the wrong result 39% of the time. Can you imagine if 39% of Toyotas had no brakes? Enough reputational damage was done in that example, by a much smaller failure rate. Can you imagine if every time you bought a tin of beans, 39 out of 100 tins of beans you bought were empty? Would you buy the beans? Would you imagine if 39% of space shuttles didn't work? Is anybody going to get in a space shuttle? If 39% of doctors weren't fit to practice, or if any other field of human endeavour deliberately designed a 39% error rate, would it be tolerated? And of course it wouldn't. So why does it have to be tolerated for you, or me, or any injured victim? Especially when they didn't want to be there in the first place. Of course the imbalance is great if you don't know where to go for legal advice. Now if you're lucky enough, or sensible enough, to be in a trade union, you're probably going to find that your trade union have checked out some lawyers that they're happy to work with, and you'll have access to the legal services through that union. If you're not in a trade union, I would say join one now, because things are not going to get better for the workplace health and safety. They are only going to get worse as things stand. Imagine if you were the employer and you know that your workforce isn't going to be able to sue you. We already know that accident rates are about a half in a trade unionised workplace to a non-unionised workplace. These proposals would mean that a trade union could not get back from the insurance companies any provision against the costs that it's made to the case. So in other words, if they win, they get back a small amount to cover the risks of loss. And they pool that together in one lump sum, in one fighting fund pool, which fighting fund they will use to pay the insurance company's costs when the case is lost. What's being proposed is taking away the union's ability to create that fighting fund, thus preventing them being able to take on the insurance industry on a level playing field in the future.